So we're now going to move to a very special part of this program. And it's one that's really bittersweet for me. And as I mentioned earlier, as we began, when we had our first webinar on this subject, and Richard gave a brilliant address based on his book as written, we wanted to have a judge who would kind of interact with Richard and be really open to the ideas, but also press hard on where the challenges were. And as I thought about the many friends, I'm very lucky. I have many friends who are judges and judges who I've had contact with at Harvard Law School. But there was one person that I knew would be perfect for this role. And that was Chief Justice Ralph Gants. He's the Chief Justice. He was the Chief Justice of the Massachusetts Court of Appeals, the highest, the Supreme Judicial Court, the highest court here in Massachusetts. And more importantly, a lifelong friend. Ralph and I had gone to law school together. We were on the law review together. We'd kind of grown up in the law, and I'd seen Ralph over and over again be open to new ideas, but also have really the utmost kind of wisdom about how to think about those ideas and what they really meant, and how to push back on what might be the conventional wisdom, but also the new wisdom. And so we asked Ralph whether he would agree to do this, and he very generously said yes. And he was magnificent, as Richard and I have spoken about since. Little did I know that that was the last kind of public opportunity I'd have a chance to be with Ralph. We actually had, as a follow-on, several conversations over Zoom about his efforts to think about bringing the best of the online world to the Massachusetts court system, particularly to increase access to justice, which he cared deeply about, especially in the areas of landlord-tenant law, where because of the pandemic and the economic crisis, so many people were facing eviction. How were they going to do that in a fair manner? But also in many other areas as well. And he had just released a major path-breaking a report on racial justice in the Massachusetts court systems, which he had commissioned long before the current moment when such issues have become front and center in many of our consciousness. And so it was just a tragedy for me when Ralph had a heart attack and shortly thereafter died. And here at the Center on the Legal Profession, we have had an award, which we call the Award for Professional Excellence. And I'm just going to share my screen just for a second so I can tell you just very briefly about it. There it is. See, there's an order of operations in Zoom you have to get right. And since 2015, we have been giving awards to leaders in the profession who we think uphold the highest ideals of our profession. And we do it around a theme. So you'll see in 2015, we had an award, a theme around women as lawyers and as leaders, and we honored some of the pioneering first women in the bar, the first female president of the ABA, the first general counsel of a Fortune 500 company, the first chair of a major law firm. We then did one on general counsels and honored leading general counsels there, including Brackett Dennison and Sabine Chalmers and Bharat Vasani. We then had a fantastic program honoring Black lawyers, in which Ken Chenault, CEO of American Express, Sarah Lynn Eiffel, Director Counsel of the NAACP Legal Defense Fund, Judge Williams. We did something on the future of work, where we honored a leading tech pioneer, Mark Harris from Axiom, and Kim Rivera, who's the General Counsel of HP. And last year, we did something on transformative lawyering where we honored Amy Weaver, the General Counsel of Salesforce, and Lou Caden. It gives me great pleasure this year to bestow our award for professional excellence on Chief Justice Ralph Gants. I'm not going to say much about his amazing accomplishments because my dear friend Harold Koh and his dear friend Harold Hongju Koh is going to give a lecture in his honor in just a moment. But I'll just say this, no one exemplifies professional excellence more than Ralph. And we are so deeply honored here that his longtime life partner, Professor Deborah Ramirez from the Northeastern Law School, has agreed to briefly come and accept this award in Ralph's behalf. So Debbie, I wish I could hand this to you. I wish I could hug you. I had a chance to honor Ralph in a wonderful ceremony we did at Harvard Law School about commemorative about his life and achievements. But this is the most well-deserved honor I can imagine bestowing. So Debbie, thank you very much for being here to accept this.
Thank you. Is it possible to see me now? Are you?
I think, yes, you are being seen. Maybe if I stop sharing my screen, that'll help. Yes, oh, right. Sorry, the back end, we have a back channel too, so my terrific team is telling me what I can see and what I can't. But please, go ahead.
Well, thank you very much, David, for honoring Ralph with this award for professional excellence. He would have been so proud and so pleased to receive this. Like many judges, when the pandemic hit, he was thrust into a turbulent sea without the skills that he would need to navigate it. I mean, if the courts are closed, then how, he thought, could they continue to administer justice? And that was a question for him and courts across the country and across the globe. He needed new skills, insights, and a way to reimagine the court system. And so the Harvard Law School Center for the Legal Profession stepped into that breach to provide United States and international judges with the advice, wisdom, experience, and tools that they would need to create virtual courts. Now, Ralph was thrilled and excited to be part of this important enterprise. And as a scholar, a judge, and the chief administrator of the Massachusetts courts, he brought real-world experience into your arena. He was also profoundly and deeply grateful to Professor Richard Susskind for his guidance, advice, and scholarship. Richard, he was reading your book on the Cape just before he died. And he took it with him everywhere, to the beach, to back home, to the porch. The center and Professor Susskind provided life preservers to the courts as they struggled to navigate these new and turbulent waters. And more importantly, as you've discussed this morning, the center encouraged Ralph and other judges to use technology not just to automate what they were already doing, the existing legal processes, but to reimagine how technology might transform the court systems and improve global access to justice. For Ralph and other judges, the center provides courts with access to thought leaders, scholarship, empirical studies, and the data that can help them address the challenges they are now facing and design a blueprint for the future. He was honored to be part of that creative and important endeavor. Thank you for honoring his participation in it. And finally, he of course would have been thrilled to have his brother of choice, Harold Koh, deliver today's Ralph Gants Memorial Lecture on the Future of the Courts. Harold was Ralph's roommate, confidant, and friend. And Harold, Ralph admired your commitment to making the international court system fairer and more just. And just as importantly, He shared your passion for the Boston Red Sox. So thank you, Harold, and thank you, David, for giving this award to Ralph.
Thank you, Debbie. We cannot thank you enough for being here. And you also, thank you for giving Harold's introduction. I do not have to give his introduction other than to say, along with Ralph, he's one of my dearest friends in the world and one of the leading scholars in all the ways you know. But rather than hear from me about Harold, we want to hear from you, Harold. So Harold, please.
Thank you so much for my technological expertise. When you see me touch my necktie, it's a signal to move on to the next slide. So here it is. Next slide, please. I have a brother. I have brothers. I have a brother-in-law, but then I have brothers in the law, and they include David Wilkins, who I've known for many, many years. I have sisters in the law who include Debbie Ramirez. But one of my chief brothers in the law was Ralph Gants. We were friends for 45 years, and he was really one of the people in this world I loved and admired the most. To paraphrase something I once heard him say, maybe somewhere in this world there's someone as smart and kind and admirable as Ralph. But I don't know if I've met them yet, and I don't know if I ever will. Next slide, please. We were part of a very special group of friends from Harvard Law School who went on to live parallel lives. Larry too, Scott Gilbert, Ralph, and I. They were roommates, and I used to horn in, and we've stayed together. In fact, our last Zoom call was the morning before Ralph passed away. Next slide, please. As Debbie said, Ralph was always rooted for the underdog. This is important to the message that follows. And so we were thrilled when he became the chief of Red Sox Nation. And in fact, throughout the first pitch at Fenway Park, the last time I saw Ralph was in Chicago at a friend's daughter's bat mitzvah. And we happened to go to Wrigley Field, where we saw the other great underdog team, the Chicago Cubs. And so we had to take this picture in front of the statue of Ernie Banks. As an intellect, Ralph was a giraffe. I mean this only in a complimentary way. He was a visionary judge and lawyer. His feet were always on the ground, but his head were in the clouds, because he had an extraordinary capacity to think about the present and the future at the same time. Somehow he could always look up from today's work, and he had tons of work to worry about tomorrow's problems. And so he thought about access to justice, racial justice, criminal justice, and the topic of these remarks, courts in the cloud. When we originally scheduled this, I put "the future is now?" ? But then I realized there was no need for the question mark. Richard Susskind's book is called The Future of Courts. Ralph knew the future is already here. We've spent 8-9 months with online courts. So because of COVID-19, courts in the cloud are here. Ralph saw immediately that necessity was the mother of invention. He and Judge Mark Green and Chief Justice Carey, in a 3 Chief Justices letter to the Mass Bar in May, said, long before the pandemic, we recognized that the civil courts will need to resolve matters without the need to come to a courthouse. By doing so, we'd enable lawyers to reduce time and cost, spare litigants from the need to miss work or find child or elder care. As always, Ralph always thinking about human needs. And then this very prophetic sentence, I know it just sounds like Ralph. Even when this pandemic is behind us, we don't believe we will or should go back to doing things the way we did. We will not only keep the wheels of justice spinning, but also work to create a better spinning wheel. So if we are talking about courts in the cloud, if I was talking to Ralph today, what would he want and what would he value? First of all, Ralph would want to know what's actually going on. Let's not just speculate. Let's hear from the front. And we just heard a wonderful panel doing so from 4 outstanding lawyers. How are online courts actually working? This is something that I follow in the international area. I do lots of international arbitrations and also cases before the International Court of Justice or in the domestic domain. I've done interviews with federal and state judges, arbitrators, mediators, trial lawyers, international lawyers, arbitration counsel, both inside and outside the federal government. So what follows is a very truncated version of an article that will be in the Ralph Gants Memorial Symposium in the Boston College Law Review, in a symposium that'll be held in the spring, and an article that will be published in the fall. For all of you who want to know more about Ralph's amazing career, this symposium volume, which has been thoroughly planned by a group of us who are working with Debbie, will tell the entire story of Ralph's remarkable range of legal issues and legal commitments. Ralph's goal, as expressed in the spinning wheel letter, was civil disputes resolved equally thoughtfully but more efficiently. Obviously, efficiency, savings in time, cost, travel, environmental savings with a reduced carbon footprint follow from online courts. But what about equity? It's easy when all participants are sophisticated repeat technology users, but it's harder to maintain when all the participants are not. So let me start with online international adjudication at the International Court of Justice in The Hague, where I've appeared on numerous occasions. In tracking there have been 3 hearings, all jurisdictional, straightforward set pieces. The bench is very passive, there's little back and forth, and so it's been a complete success. There's no questioning, and so well suited to video hearings. The real test will obviously come in merits hearings where evidence is advanced and witnesses are examined. But it's already clear that if this continues, it'll advantage repeat players at the ICJ bar and develop world counsel who have the resources and adaptability to handle such proceedings efficiently. Also in the Peace Palace at The Hague is online permanent court of arbitration, arbitration between states, state to state arbitration. Now, as you can imagine, they initially said it would be inappropriate to have video. Then the ICJ announced that they would have video, and so they finally decided quickly it was appropriate. What I've heard is that after COVID, they'll likely return to in-person hearings for witness-intensive hearings, but use video for procedural meetings and lower budget issues as they did not before. Kathleen spoke about what she called the majesty effect or the formal effect. It's in the interstate setting, a gravitas effect. A lot of nation states trying to make deals like to have the formality of an in-person proceeding at the Peace Palace so that it gives a kind of imprimatur. And globally, symbolic proceedings of this kind will probably move back to in-person proceedings if given the opportunity. What about online arbitration between investors and states? Just to take an example from the World Bank arbitration before the ICSID, I've been advised that, as one person gently put it, the pandemic has successfully forced a lot of older people to get up to speed electronically very quickly. Technical preparation and testing are key. The technology has been up to the challenge. And in fact, there's been a democratizing effect because costs have been reduced. And as said, counsel and clients can get in the room who might not be able to get into a room in a hybrid proceeding. The effect has been more focused advocacy, but the timing of these proceedings limits to about 5 hours a day, which often makes hearings last much longer, but forcing better preparation, with Zoom fatigue affecting the overall quality of such proceedings. Next slide, please. The downsides are it's harder to get multilateral negotiations going, harder to draft agreements. I'm sorry, go back, please. Post-deliberation hearings, post-hearing deliberations and pre-hearing preparation are impaired. And the biggest issue is time zones. So for example, if you have a hearing, in fact, this conference is an illustration, US, UK, Europe, Middle East, and Singapore, the number of usable hours of the day is only 4.5 hours. And that means that the chair would have to sit at 1 a.m. Hybrid proceedings have been possible. You heard from Colin Passmore, but few have really tried. And as mentioned, the video loses the social appeal of bringing people together in person, as well as the natural tendency of counsel to try to show off for the client. These factors will collectively create pressure to revert to in-person hearings again, once that becomes possible again. Some of the key difficulties, and next slide please, is remote simultaneous interpretation. Zoom is the best, but the UN prohibits it because of security reasons, which may now be outmoded. Ironically, as pointed out, technical difficulties from large law firms usually arise when big name partners expect to delegate technical matters to the help rather than learn it themselves. Barrister and counsel are frustrated because they think their value added is cross-examining witnesses live, although some think that proceedings are better from the tribunal's point of view, and uncooperative parties can totally disrupt an online hearing. Next slide, please. This will raise 3 questions. Will this overly favor the repeat player bar? How much will courts and other bodies adapt and learn from the pandemic experience? And then an interesting question, can an arbitral tribunal order a virtual hearing over the objection of a party? The answer is probably yes, as a matter of inherent power, but due process principles are often invoked. The Austrian Supreme Court has already ruled on this issue, saying it's not a violation of the European Convention of Human Rights, but it specified some remarkable details, including, for example, the requirement that a 360-degree scan of the room be done to make sure that no text messages were being sent to prep the witness. The 2 qualitative issues are whether video will allow development of trust needed for all aspects of preparing the case. And as one person put it to me, will remote justice make justice feel more remote? And that person gave this somber assessment. While this is manageable in the short term, there's a real risk of systemic degradation if this becomes the long-term norm. Next question, next slide, please. How about online domestic alternative dispute resolution? I've talked to lots of domestic mediators. The best line was, I now understand why online dating works. You can actually assess people's personalities, and the logistics are simpler, the cost is lower, the decision makers more likely to appear, clients are relaxed and happier, it's easier to talk, everyone behaves better because they can see how others see them. But there's no schmooze factor. You don't bump into each other in the hallway. You don't break bread to break the ice. Next slide, please. So mediations tend to resolve faster, but there's a lower settlement event effect. For example, the classic moment where someone says, I'm going to the airport and I'm not coming back. Forcing the settlement is hard to when you say, I'm in my house and I'm going to turn off my Zoom screen. Lawyers have less control of the clients, and the mediator has less ability to get in the face of the parties and to get them to resolve. But the mediators I've talked to says, look, we're not going back. It's just so much cheaper. The question is no longer when do we travel, but why should we travel? Next slide. On online domestic courts, you've just heard from an expert panel. Let me just add, with sophisticated repeat users, online hearings are going well, especially with oral argument, less so with cross-examination. One person I talked to said, no one else will ever again pay a lawyer to wake up in the morning in New Orleans, fly to Houston, do a couple-hour hearing and fly back and bill 15 hours. The main hesitation is, of course, criminal jury trials, taking pleas, any issue that involves individual dignity, significant losses of liberty. And in many cases, the worries about the juries are very huge because very few jury summons are being answered during a time of COVID. The Lackawanna, Pennsylvania court system just allowed judges to remove peremptory challenges to make sure the decline of citizen responses doesn't strip the jury pools of going below 6. And nobody wants jurors to decide cases from home where their children are running around, the TV is on, or they can multitask. As one person put it to me, well, our in-person system works in part because everybody's uncomfortable and wants to get out of there as fast as possible. I have a question for the Master of the Rolls, Sir Geoffrey Voss. When I was a student at Magdalen College, Oxford, I met another alum, the great Lord Denning, also the Master of the Rolls, and he said something to me in that moment that he later put into a famous opinion. As a moth is drawn to the flame or to the light, so is a litigant drawn to the United States. It's turned out that video has authorized many US domestic arbitrators to go international, which raises the question whether European and UK litigants will be more drawn to US forums as they become increasingly available online. One of the issues that's addressed in Richard Susskind's outstanding book. In all of us, I think we need to focus on what Ralph Gants would insist on: protecting the vulnerable, dignity through participation, protecting advocacy, mitigating asymmetrics, preserving accessibility, and honoring complexity. And let me say a word about each. In his commentary about Richard Susskind's last book, Ralph pointed out that written forms of advocacy can disadvantage those who don't write as well and are good at oral advocacy, a point that Kathleen just made. He pointed up that up to 25% of his cases, oral argument changed some aspect of his reasoning. Asymmetry of knowledge and skills create inequities, especially with repeat players like creditors. Next slide, please. Accessibility. On this, Ralph said something that really was on point and prescient. Courts must meet the users where they are. That means language access, how to develop written translation for non-English speakers, and technology access. Ralph said, wouldn't it make more sense to develop an online system through smartphones, not computers, given that so many more Americans have access to smartphones than Zoom? My wife, Christy Fisher, works for Connecticut Veterans Legal Center. None of her clients, former veterans, have Zoom. And most of them have smartphones that have a very limited number of minutes. We have to meet these users where they are. So coming to the conclusion, complexity and dignity are where Ralph really focused. He rejected the idea that everyday legal disputes are simple. He said it could be much harder to decide much harder to decide a case about child custody or eviction than a civil suit with a lot of dollars involved. And he emphasized dignity. Justice is not the only reason the result that emerges, but the feeling somebody has been heard. At Ralph's investiture at the Superior Court, he said that his own judge had told him, we can't make this whole unfair world fair, but we can and must do everything we can to make this courtroom a place where fairness, justice, and civility rule. I think Ralph would be committed that even in the cloud, courts can and must still be places where this is true. Ralph's request would be that courts in the cloud preserve core humane values. Of course, efficiency and cost savings, but equity, fairness, due process in the eye of the receiver, dignity, participation, and respect for public health. And finally, can we even dream, as Leonora did, of online courts that can deliver better justice than we have? When we were very young, Ralph and I used to talk late into the night about the problems of the world. One night we made each other a promise. If we grew up and we ever got to positions of influence, we'd do everything we could in our power to make the world a fairer place. Ralph kept his promise and he used his power in all he did and how he saw the future, and he was cheated out of time. But as courts in the cloud develop, and they are here now, the question he leaves for us is, will we keep our promise? Thank you, and thank you for letting me make this memory of my brother-in-the-law, Ralph Gants.
Harold, what can I say? Thank you so much for those beautiful remarks. You know, Harold and I and Debbie, we all said Ralph would want whatever we did to be substantive, because he was a deeply substantive person who cared about these issues. And in honoring his commitment to substance, you have honored him as a person and as a friend in a magnificent way.